Now to the high court in our state. Twice a year, the Minnesota Supreme Court justices go to a high school as a part of its traveling oral arguments program. And today, the court visited Richfield High School and they heard a case, oral arguments for Alejandro Cruz Guzman versus the state of Minnesota. And this is a case that's been ongoing for years about whether states should intervene in schools that are racially segregated. For the story, here's Sharon.
After a long journey through the district court systems, Cruz Guzman v. Minnesota ended up at Richfield High School in front of the Minnesota Supreme Court for its oral arguments. The appellants argued that schools made up primarily of students with the same racial and socioeconomic backgrounds deprive students of color their constitutional right to an adequate education. They don't want students of color to represent more than 20% of the population at any school, or for one racial group to make up more than 60% of the school.
We believe that in a multiracial, multicultural society, a system cannot do that if it tolerates and fails to remedy racial isolation that persists in two of the largest school districts in the state.
The state, the respondent, is arguing it shouldn't play a role in defining the quality of schools.
Our system of education, like most states, does delegate a fair amount of control to local school boards, with the idea that local school boards have the closest relationship with the local communities and know what's best for the children in those communities.
Then there's the third party, the interveners, representing charter schools like Friendship Academy, where 93% of its students are Black.
The interveners understand that the courts do need to be involved in defining what a high quality education is, but it needs to be something more robust, more comprehensive than just the racial makeup of a school.
Josh Crossan, the executive director of Ed Allies, an educational nonprofit that primarily serves historically underserved communities, explains that by the appellant's definition of, quote, racially integrated schools, places like Friendship Academy would be unconstitutional because it's, quote unquote, too homogenous.
Friendship Academy is a school that is designed by and for communities of color, specifically Black Minnesotans, to learn about history and art and study communities of African-American heritage in order to allow students the ability to kind of self-identify in a really strong and founded way within their Blackness. For all intents and purposes, it's a good school. Now, according to the plaintiffs, this would be a bad school because it's predominantly Black students.
As you can tell, a complicated issue. That's why it's gone to the Supreme Court. The court heard arguments from all three sides today, and then the court issues its opinion. That's going to be sometime in the next several months. And it's fully possible that this case would get kicked back down, meaning it would go back to the lower court for a full trial. So